Yeah.
Okay. I have two monitors going over here, so I'm kind of in a.
Sure.
Okay, so I'm gonna pull in Mr. Stone as well as Mr. Cataldo because he writes on all their files.
Is Mr. Rodnick here too?
Mr. Rodnick is here and Miss Kennedy is here as well.
Okay.
First, Howell and Milton. Okay. No.
Afternoon, Judge Oster.
Good afternoon.
And now I have to remember which, okay, so. I have to see, that's, no.
You know, do they have to do it one at a time?
I'm sorry?
When they're in jail, do they have to do each one at a time?
We have been, and I have the jail signed on in like 4 different rooms. So I have to figure out which room that Mr. Melton's in. I know that Miss Howell is in room number 3.
Okay.
So I was trying to figure out who was in which room, but I couldn't.
Well, usually they are kept separate, and it's really important that Melton be kept separate this time because he made a statement, and I don't think the others will be physically leaving him alone if they're in the same room with him.
So do we want to do, I know where Howell is. I don't know where Melton is. Do you want to do Melton first? Or I mean, not Melton, Howell first and then Melton?
Either one's fine. They're both going to
Okay.
be put over.
Let me find Miss Kennedy. Here, I'll bring in Miss Kennedy on Howell. Deputy?
Hello,
Can we have Miss Howell?
Howell.
We all set then? Okay. It's People of the State of Michigan versus Delaney Howell. Counsel, if you'll place your appearances on the record, please.
For the record, William Cataldo appearing on behalf of the people.
Good afternoon, Your Honor. Robin Kennedy appearing on behalf of Ms. Howell is present via the Zoom application and Polycom from the Macomb County Jail. She does waive her right to be physically before you today for purposes of today's proceedings.
Thank you. And have you begun to get the discovery, Ms. Kennedy?
Your Honor, I have begun to receive discovery. I have about 53 pages. I do expect that there is much more to come, including video and audio recordings. I have had an opportunity to speak with Mr. Cataldo. We are asking for, or we are in agreement with an adjournment of the probable cause conference at this point. Ms. Howell's been advised of her right to have the preliminary exam within 14 days and does so waive. With that being said, Your Honor, I just would like to address bond once we're able to set a new date.
Sure. Let's set the date first. So how much time do you think you need to have a meaningful conference?
Your Honor, I would indicate that next Tuesday, this is a 6 co-defendant homicide case. We have 2 of the defendants today. We have 2 of the defendants next Tuesday, and very likely at least one or two of the other ones are going to be arrested fairly quickly. There is a tremendous amount of video and materials. I would ask so that we can get all these cases sort of going in the same direction at the same time, that we look at the end of January, because we are, as the court is aware, operating on limited staff remotely. We're going to a new system that seems to have some bugs in it as we upload all of the electronic information to it to make it easier to send out for discovery. So I'd be asking for somewhere in the area of January 19th for another probable cause conference. That should give us enough time to be certain that Ms. Kennedy has all the documents that we have, as well as the other co-defendants.
Ms. Kennedy?
That would, the 19th actually works for me as well, if we're doing the afternoon.
Is that typically when your docket is set for in East Point?
Yes.
Okay. At 1 o'clock?
Yes.
Okay. At this time, then, we'll set it for 1 o'clock on January 19th. And that'll be another probable cause conference. And Ms. Kennedy, you wanted to address bond?
I do, Your Honor. Ms. Howell's bond is currently set at $1 million. I understand the nature of the charges certainly are the most severe that we do have here in the state of Michigan. However, I just want to note, in reading the amount of discovery that I do have thus far, it does not appear, at least from my view, that Ms. Howell is the most culpable, if culpable at all. She does maintain her presumption of innocence, but to inform the court, she does have family that has been incredibly supportive thus far. She has 3 children, 2 5-year-old twins and a 3-year-old. And she's never been separated from them. She was employed for 6 years as a letter carrier with the U.S. Postal Service. She has no criminal history. She did leave that position as a letter carrier in September of 2020 to provide virtual schooling for her children. She is not a flight risk. She is also was also present during the murder of her boyfriend, which happened 1 day prior to this. And she is not, to my knowledge, a suspect in that, and was cooperative in that investigation. So, Your Honor, I don't see her as a flight risk in any way, shape, or form. I would ask the court to consider a reduction to $250,000, a 10% provision with tether. And I do have an address where she would be staying. I would just ask that if given the opportunity and providing that address to the court, that I be able to do so privately and off of the public record due to the nature of the 6 co-defendants. I do believe that there have also been some threats made to Ms. Howell and her family, even from other co-defendants.
Okay, before we get to that, I'm sure the prosecutor may have a response, but
Yes.
is there any indication or allegation that the person, her boyfriend who was murdered, was related to, is there any relation between the 2 cases, if the prosecutor knows?
Yes, Your Honor. The boyfriend that was murdered is the brother of the main suspect in this case, Lonnie Bell. And the person that was murdered in this case is the father of her child. It would appear from phone records and other information that the prosecution has that after the murder that she did witness and did admit that the victim in her case was the one who shot the current boyfriend, that it was her who put into effect the notice to the individuals that she associates with that are down in Knoxville, Tennessee, to then come back to the Detroit area, as well as meeting with them prior, as well as information that we have indicates she pointed out where he lived and other things. So it's not like she was just simply present at the prior homicide and is aware of this one. We believe there was a more active role that she was taking in this. So, I mean, we'll leave bond to the discretion of the court, but clearly we would wish it to be a high bond because of the action in this particular case.
Okay. Given the nature of the seriousness of the charge, Ms. Howell, at this time, I'm going to deny your attorney's request to reduce bond. And is there anything else on this case?
No, Your Honor.
Nothing from the defense, Your Honor.
Okay, good luck, Ms. Kennedy.
Thank you.
Good luck, Ms. Howell.
Robin, give me a call.
Oh.
Nope, that's okay. I'll call her. There was a couple of
Ask
issues
who my
on-
secretary is.
No problem.
Okay, so let me try to pull in another jail here real quick. Hello? Oh, that's Mr. Norton. Yes, I've never had the jail. I've never had so many different rooms for the jail.
Right.
What is your name?
Michael Pepizzo.
Okay, so Pizzo's.
Did you ever have 3 or 4?
Put him back in. Trying to write down who's in. Wrong one again. 4.
I can initial it later.
Is anybody there? Who do you have on this? Who do you have? I can't hear you.
I have Pool coming out right now.
You have Pool. Do you know which room Mr. Melton's in?
What's the last name?
Melton?
I don't, I can call down though.
Yes,
Do you want me to
'cause
call for you?
I'm not sure. I have the jail in quite a few rooms and I'm looking for Mr. Melton.
Melton, okay, give me just a minute.
Thank you. So Pool is 4. There was another one in here that's gone now, so I bet you that was.
Do you have floor 6 that is showing up on your screen?
I have floor 6. They have Mr. Norton in the room right now.
Okay, because that's where Milton is as well.
Okay, then I will tell Mr. Norton to get Mr. Melton.
Okay,
Thank you.
you're welcome.
I think it's gonna be another minute.
Mr. Norton,
Yeah.
can you tell the deputy that we're looking for a defendant Melton, please?
All right.
Or maybe in the same.
They're asking for a Milton. Milton. Oh, yeah.
Yeah, he's in the gym.
Yeah.
All right, I'll call. He's down in the gym area.
They just told me he was on room 4. Okay,
Yeah, we had to take him down there because the system broke in the other room, so I had to take him down there.
okay, I'll try there then.
Okay.
Thank you.
You're welcome.
Okay. One more time. Deputy? Deputy?
Hello.
Hi, do you guys have Mr. Melton down there?
Javon Melton?
Yes.
Melton?
And I'm bringing in Mr. Rodnick now.
Thank you.
Yes, sir.
All right, I'm in court now. I have to go. Bye.
Okay, this is People versus Javon Martiz Melton. Counsel, place your appearances on the record.
Thank you, Your Honor. Randy Rodnick on behalf of Mr. Melton.
Bill Cataldo appearing on behalf of the people.
And today's date and time set for a probable cause conference. Have you had a chance to talk to your client about the exam and the fact that we probably will have to set it out beyond the 21 days?
Yes, Your Honor, I have.
Okay. And will he be waiving that right today?
Yes, Your Honor, he will.
All right, Mr. Melton, you understand you have the right to an exam. It just wouldn't be 21 days from the date of the arraignment.
Yes.
That'll give your attorney an opportunity to get all the discovery and all the documents, video that may be available to give you your best defense possible. At this time, I find
Yes, sir.
your waiver to be freely given, and I find good cause to adjourn the exam. Mr. Rodnick, we set the probable cause conference date for January 19th at 1 o'clock. Is that a good date for you?
Let me just check 1 second, Your Honor. I'm sorry. January 19th
Yes.
at 1.
Yes.
That's fine.
Okay, great.
Excuse me, Your
I-
Honor.
Yes, sir.
Do I supposed to receive a copy of my discovery? Because I haven't, sir.
I mailed that to you. You'll get it,
Oh,
Mr. Melton.
okay, fine. Thank you, sir. I didn't know. Thank you.
Okay.
Your Honor, I did have a couple motions that if I can address those real quick.
Go ahead.
They're really easy. I have a COVID bond motion because the COVID's in there and my client has some propensity for illness. So I wanted to address that. I think his bond right now is 2 million cash surety. I know that Mr. Cataldo will agree that my client is the less culpable of most of the other persons involved in this case. I would just ask for some type of a bond scenario. That would be something that's possible, that he possibly could do.
Mr. And I would indicate, consistent with the facts that the court heard with the prior defendant, this is a very serious case. The issues with Mr. Melton and several of the others is this is an organization that seemed to operate between Detroit and Knoxville. And in fact, during the investigation, many of the individuals left the state, went back to Knoxville in the Tennessee area. And there is this fear that if released, we may have a difficult time finding them. On the other hand, Mr. Melton has, through his attorney, been productive for us. And I just think that the motion may be a little bit premature. I'm fairly certain we will work with Mr. Rodnick to find something reasonable after the preliminary exam, but we would ask that the bond remain the same until that time.
In light of all the circumstances, Mr. Melton, the purpose of bond is to ensure your reappearance and the safety of the community. I'm going to deny your attorney's request, but that's a denial without prejudice. He may bring that back up at any time.
Thank you, Your Honor. And also I had one more. I wanted to just preserve any and all of the videotapes, any tapes. I think there was a gas station tape to preserve those videotapes. Obviously, I know Mr. Cataldo will do that. I just wanted to protect the record to indicate that I do want anything of that nature preserved. And I didn't include, but I would also any 911 calls preserved.
Your Honor, we obviously, Mr. Rodnick is correct. We have some surveillance videos and others. All of that is being preserved. And I also spoke to the detectives today from East Point, indicated that I wished all the vehicles that have been confiscated, even though they have been tacked, that they are to be held in case defense counsel wishes to have their own independent experts take a review. So everything is being currently held. There is a tremendous volume of documentation in this case, aside from the police reports here through the U.S. Marshals down in Knoxville, the Detroit matter that ties into this particular case. So there is a tremendous amount of discovery. And as soon as we have all of that marshaled, we are going to be sending it out as it comes in.
And Mr. Cataldo, again, you believe that the 19th is far enough out to get the attorneys that information so that they can review it before the hearing?
Certainly to get us started, Your Honor, I believe we'll use that date to set another date, which will probably be a firm date. Well, with 6 co-defendants, or at least a minimum of 4, it's probably going to be 2 different exam dates anyways. So each case may have a slightly separate set of requirements, but I think at least that gets me out far enough to know that I have enough discovery to go forward, at least to exam phone records, things like that. It's clear that we're going to need at least 8 weeks total before that first day of exam, but I like keeping it relatively shorter so that I know exactly where we are and defense counsel knows where we are. They can let me know if they have any disagreements with what information we have and what's been turned over.
Okay, thank you. Is there anything else, Mr. Rodnick?
That's fine, Your Honor. Thank you so much.
Okay, have a good day. Good luck.
Bye-bye.
And which one are we going to now?
Okay, I was gonna move to Kumar's right now.
Okay.
He's got a Norton and a Hagen.
Okay,
And Norton is in custody, so I will bring him in first.
okay.
Where's Mr. Kohler?
People versus Jason Morton. If you'll place your appearances on the record.
Kumar Palapu for the people, 74099.
And
Like
Mr.
this-
Kohler? Is he connected?
It doesn't look like he's connected. There he goes.
Good afternoon.
Good afternoon, Mr. Kohler. Today, would you state your appearance for the record, please? Mr. Kohler,
All right, I'm Tim Kohler.
okay. Have the two of you discussed your motion?
Yes, Your Honor. So, as far as this case is concerned, Livingston County has filed charges for offenses that occurred in their county. I've been in conversations with them about how they intend to proceed, and being that a multitude of the offenses that I had charged took place in Livingston, I'm moving to dismiss my case today, and I believe that the defendant will be transported to be arraigned on the charges in Howell, which is the 53rd District Court. I did check in lien, and those charges and a warrant is active, and I believe that East Point is going to transport the defendant from Macomb County Jail over to Howell to be arraigned.
So in essence, you're joining Mr. Kohler in his motion then?
I would just say that I'm moving to dismiss, and I don't know if I haven't really had the time to address his motions. I did see them, and I'm not dismissing them for necessarily any of the things that are taking place in his motions. And I know that his motion, and one aspect that I did see a blurb of dismissing with prejudice, which there has been no prejudice, so that isn't going to happen. But as far as what I'm doing is I'm just moving to dismiss because as I understand, Livingston has filed charges, and I believe it's more appropriate for them to prosecute the defendant in their own jurisdiction.
Mr. Kohler, any objection? Mr. Kohler?
Well, I never object to a prosecutor's motion to dismiss. Yes,
Okay.
maybe. No, I'm good.
Okay. All right. So at this time, Mr. Norton, the charges in Macomb
never-
County are dismissed. I think he's muted.
Yeah, I'm trying to unmute him and because I was getting bad back feed from the,
Right. I heard that.
and I don't know if he knows how to unmute it. Oh, there we go.
Mr. Norton, so do you understand what's happening? The charges in Macomb County are dismissed. You're likely to be transported to Lucas County.
Yeah.
Okay. All right. We're all set then. Good luck.
Thank you.
Thank you, Judge.
Nice to see
Kumar,
you.
Yes, sir.
I will be emailing you relative to Dalton a little bit later.
Oh, sounds good. Okay, I'll look forward to it.
All right. You
Have a
look good.
holiday, Tim.
Yep. And Kumar, if I don't see you again, Merry Christmas.
Merry Christmas, Tim.
Give those girls a hug.
I will. Thanks.
They are special.
I appreciate that. Thank you very much.
You bet. All right. Bye.
Bye-bye.
All right. We're going to go to Hagan now.
Yes.
Yes, sir. This should be quick.
Okay.
Hello.
Hi, Mr. Hirsch.
How you doing?
Good.
And is okay, he's connected now too, it looks like. All right, this is People versus Robert Lloyd Hagan. Counsel, identify yourselves, please.
Kumar Palapu for the People, P74099.
Harry Hirsch for the defendant, P14997.
Okay. And counsel?
Your Honor, Mr. Hagan, could you just state your name for the record?
Robert Hagan.
Your Honor, today's the date and time set for a PCC. I did get into a breakout room with Mr. Hirsch, who said that he wanted to request from the court an in-person exam date because we do have a minor. So that's what we were going to ask for today, a possible date for a future exam.
Okay.
And Your Honor, I'm older than dirt, so I would like to put it out as long as possible so I can get the inoculation before.
Right. I was hoping you weren't going to say so your successor can take it. You're not that old. You look pretty good to me. So, yeah, I mean, I don't know what, okay. And then if there's still concerns by the date that I set, you can always just talk to the assistant county prosecutor and
We'll take it before the court at that point in time and see what we can manage.
so, I mean, do you think March is far enough out or no?
Yeah, I think that's far enough out. We're supposedly in the next group.
Yeah, okay. How about
Whatever
the
that
3rd of
means.
March?
3rd of March, you said, Judge?
No, the 23rd.
23rd? Okay, so that would be the...
I'm sorry, can I just interject really quick? For an in-person exam, right now, are scheduling them for Wednesdays at 1.
Okay, so the 24th maybe, is that?
Yes.
Okay.
That works for me.
Mr. Hirsch, does that work for you?
The 24th,
Yes.
3:24, 1 o'clock. Yes, that's fine.
Okay, great.
Thanks, Judge.
Okay, thank you very much.
Thank you very much. Have a Merry Christmas.
And I do find good cause to continue to adjourn the exam.
Thank you.
Thank you.
Christy, can you call Capizzo with Mr. Harding so he can get to his meeting next?
Yes.
Are we all set then?
Yes.
Yes, sir.
Here's Mr. Harding. So we're going to go to Capizzo.
No, I have Taylor.
And where's Miss Barrett?
And Ms. Barrett, I think you're muted.
Okay.
This is the People versus Michael Robert Capizzo.
Yes. Good afternoon, Your Honor. William Harding of
Right,
P28342 appearing on behalf of the people.
Thank you.
Good afternoon, Melita Barrett on behalf of Michael Capizio, P432238. Judge, I had a chance to talk to Mr. Capizio about his right to a preliminary exam, and he wants to waive his right to a probable cause hearing in this matter.
Thank you. Can you unmute him? Okay,
Yep, I'm trying it.
sure, I know.
I see the deputy there coming down.
Deputy, can you unmute the monitor, please? Okay.
There we go.
All right, Mr. Capizzo, you have the right to a preliminary exam, and if you give up that right, you will not have to put forth any evidence against you, and your case will be sent to the court for a pretrial arraignment and then eventual trial. Do you understand that?
Yes, sir.
And is that how you want it to go?
Yes, sir.
Nobody's forcing or threatening you, are they?
Nope.
And are you satisfied with your attorney's representation so far?
Yes, sir.
All right, I find that you are freely willing and voluntarily waiving the right to exam. You are bound over as charged. Sent to the 16th Circuit Court of Mount Clemens for an arraignment pretrial.
Your Honor, an arraignment and pretrial has been scheduled for January 5th at 9 o'clock before Judge Marlinga.
Okay, great. Thank you so much. And is that a good date with you, Ms. Barrett?
Yes, it is.
I had to unmute him because the judge wanted to make sure he understood, but it is for January 5th at 9 o'clock.
And is there anything else?
No.
At 9 o'clock or at 1? It's at 9?
I believe Mr. Stone provided me 9 o'clock as the time, Your Honor.
Okay, that's with Judge Marlinga?
Yes.
Yeah, Judge, in custody, Marlinga would be 9 a.m.
Okay, thank you. Is there anything else?
Nothing on behalf of the people, Your Honor.
No, Judge.
Okay, thank you. All right.
Thank you,
Have a
Your Honor.
good day. Thank you.
All right, how about Raekwon Taylor, Melissa Simmons?
That's what I was going to ask if you wanted to do that one next. But you know what, though? I don't see Mr. Sheik,
Okay,
which is very surprising.
I will text her to get a hold of him. I guess then, I think JP has a few files. Collins, Evans, Nixon, and Poole.
Okay, and I think Mr. Van Team, you know what, I'm going to bring Mr. Van Team and the jail in and put them in a breakout room real quick. I tried to get them all done before we started.
Okay, we're ready on Collins. Collins is going to be a waiver and an adjournment.
Okay, I'm going to pull real quick Mr. Van Team in the jail room floor. Are you Mr. Poole?
Yes, Your Honor.
Yeah, Poole.
Christy,
I'm just going to put Poole in a breakout room real quick.
okay.
Yes, Jeff, I'm sorry.
I'm sorry. Melissa Simmons said that Carl Jordan is handling the Raekwon Taylor matter.
Okay.
Good afternoon, Your Honor.
Hello, nice to see you again.
Nice to see you also.
I think you're going to go in a breakout room with your client.
Okay, perfect.
Okay, so we were going to do Raekwon Taylor.
Do you have the file, Melissa?
I do.
Okay.
This is going to be another one. I don't know which floor he's on. Is anybody there?
Yes, was the kid called? I'm sorry.
I'm trying to find the defendant. Well, let's go here and see if they can tell us where they're at. Hello?
Hello?
Do we know where Raekwon Taylor is? Which room or?
He's on 4-5. I can call up there and get him on the Viz.
Yeah.
You want me to call up there?
Yes.
Okay.
Yeah, because I don't even have, they're not even signed in. Can I put you guys back in the waiting room for a quick moment?
Sure.
Thank you. Now I'm gonna go to Collins, Nina. Want to do Collins real quick?
Sure. He's in custody too.
Yes, I know where he's at.
All right.
So here's Mr. Gerds. And is that, did you say that was a JP case or is that you?
It's both of us, actually.
Okay, so I'll pull him in. And then I will pull
Which one are we going to?
Collins. I'm sorry.
I have them right here.
Mr. Jerzyk, do you know who your circuit court judge is on the felony file?
I do not, because I never received a, I think I was spot appointed. I never received a order.
Oh, yeah.
Christy, do you guys know?
Let me see if it's here.
Or judge?
Oh, it's Judge Oster doing it? So it looks like he's in a breakout room right now. Through the court there.
Mr.
Taylor.
Mr. Taylor should not be, but we do need Mr. Collins.
Okay, we'll get him in.
Mr. Collins?
I don't see a judge on the file.
That's gonna ring. Keep an eye on it.
Yeah, it'll ring in next door, right?
No, it'll ring.
I mean, you can hear.
I do not see anyone on my.
Well, are we ready on Collins then?
Yes.
People versus Thomas Lee Collins. If you'll identify yourselves, counsel, please.
William Jerzyk on behalf of defendant Thomas Collins.
Thomas Collins.
John Paul Hunt on behalf of the people.
Okay. And Mr. Stone is also present. Is there
Yes, Your Honor.
a waiver today, or what are we doing?
Yes, Your Honor. There are 3 files on this matter. There is a felony file that Mr. Collins will be waiving his preliminary exam and being bound over to circuit court. There are also 2 misdemeanor files. I would ask that those be adjourned out to a date shortly after his AOI at circuit court, basically to kind of track that case. If we have a resolution there, we'll likely be able to have a resolution on the misdemeanors.
All right, thank you. Mr. Collins, is anybody forcing or threatening you to give up your right to have a preliminary exam?
No, Your Honor.
Do you understand if you not have a hearing in this court, and will not have forth any evidence against you, your case would be sent to circuit court in Mount Clemens. Do you understand that? Oh, I think he got muted.
He did, yeah, because when they have that background noise, my court recorder can't hear you.
Okay. You understand,
Your Honor.
Mr. Collins? Are you satisfied
Yes.
with your attorney?
Yes, Your Honor.
Okay. I find that you freely, willingly, and voluntarily are waiving your right to have a preliminary exam. You are bound over to stand trial in circuit court. Case will be set for an arraignment pre-trial in circuit court. We're not 100% sure who the circuit judge is, so we don't know the exact date, do we yet?
Well, the majority of them are doing Mondays at 1:30, so I guess we can roll with that. And if it's inaccurate, I'm sure we'll be notified by the clerk's office.
Would that be January 4th?
Correct.
Okay.
So we'll set it for that, and if it has to be moved, it gets moved.
Okay, and I'd like to make a bond motion as well.
Go ahead, please, Mr. Jerzak.
Yes, Mr. Collins is 23 years old. He reports to me that he would be living with his girlfriend in Roseville. He says he has a job waiting for him at Ford's Industrial. I believe that's somewhere here in Macomb County. I believe he said it was around 15 Mile Road. He's not on probation or parole. In terms of his criminal record, he says he hasn't had any kind of felonies in several years. I don't believe he's a flight risk. He did report to me that he did test positive for COVID 2 weeks ago. So, I mean, I know you'd have to obviously, follow whatever protocols the jail has for that. And he would be able to, if the court would require to be on a GPS tether. So I believe he's got a $20,000 no 10% bond on the felony. And then each misdemeanor is a 10% on a $2,500 bond. I'd ask the court to consider a personal bond or at least lowering those bonds so he'd be able to post those bonds. He's been incarcerated since early September, and so he's been in for over 90 days.
All right, thank you. Mr. Hunt?
Your Honor, I do not have a CCH for Mr. Collins at this time, knowing that he has 3 files before the court today. I would oppose a bond motion at this time, would be open for a community corrections review to see what his bond, if the bond should be lowered at the next court date.
And, what dates are your misdemeanors? Are they the same Tuesdays?
Be a Tuesday afternoon, yes.
Okay. Mr. Jerzak, do you want to set those for a week after that, like the 12th? Or
I don't mind coming back on the 5th, the day after his arraignment.
I can't do the 5th.
Okay. Then the 12th would be fine.
All right. So at this time, Mr. Collins, had I had that information from Community Corrections, I may have granted your attorney's request, but I don't have enough information to grant it this time. I think Mr. Hunt's recommendation is a good one. And so I will refer the matter to Community Corrections. They'll meet with you, write up a report, and then your attorney and you will have it when you go to circuit court and also when you come back to this court the next day. Okay? Good luck in circuit court.
Thank you.
All right. And I'm sorry, we're putting the 2 misdemeanor files off until the 12th?
Yes.
Thank you.
Have a seat, and then when he's done, I'll take you guys both back.
I believe, do you guys have Mr. Evans down there? Is this one yours as well, Mr. Hunt?
It is.
He's on his way.
Thank you.
Oh, Mr. Hunt's in the house. Uh-oh. Look out.
We're going to do Evans next.
There you go, Mr. Evans. Thank you.
No, hold on one second. I need to locate the file. Roosevelt Theodore Evans, counsel, identify yourselves, please.
John Paul Hunt on behalf of the people.
Aaron Furs Cole on behalf of Mr. Evans.
And today's the date and time set for a public cause conference. Are we going to, what are we going to do?
We are asking that the matter be set for a preliminary exam, and I would like to address bond as well.
Okay. And is this a case that could be handled via Zoom?
I'm sorry, I didn't hear that.
Is this a case that could be handled via Zoom? Like,
Yeah, I think so.
I believe so, Your Honor.
okay. And counsel, do you have all of your discovery?
I do.
Okay. So we'd be looking at sometime in January, maybe like the third week or so. Would that be a Tuesday? Like
An exam would be a Wednesday at 1.
Wednesday at 1, okay. So is the 20th good for your schedule at East Point or?
Yes. 1, that'd be fine.
All right, regarding bond?
Regarding bond, Mr. Evans is currently working. He works with he does a mobile vision company with his aunt, working with eyeglasses. But he hasn't been doing that as much because of COVID. So he is also working part-time at the car wash on 8 Mile and Gratiot. He's also helping to take care of his grandkids. The current bond that is set, he cannot make that. He is asking for a reduced bond.
Is there any history of absconding?
Your Honor, I don't have that in my file. I don't have that information in my file.
Okay. And Mr. Hunt, is there anything you wanted to say?
Other than the fact that, Your Honor, that I'm concerned about the substance abuse issues with this file. He was found allegedly slumped over a wheel when the fire department showed up and then the police showed up. So I would have my concerns. My recommendation or suggestion to the court with respect would be to refer him to community corrections as well, Your Honor.
Okay. Let's see. All right.
Yes.
How long has your client been in?
I believe he's been in since December, since this arrest, which I don't have in front of me right now. Wait, how long have you been in, sir?
Since December the 6th.
December 6th.
Your Honor, you had asked me if I do not have any information as to whether or not he has any failures to appear, but the allegations in this case are that he gave also fictitious information to the officers on scene. So that would draw my concern as well.
Sure. Okay, well, the purpose of bond is to ensure your reappearance, Mr. Evans, safety community, any particular individuals. I do agree with Mr. Hunt's concerns. So I'm going to set a bond and bond conditions that if you can meet, you can get out. If not, then I will refer the matter to community corrections. So the bond would be amended to a 10,000, 10%. You would have to have a GPS tether prior to your release. You would have to be signed up for drug testing no less than 9 times per month. So you'd have to have a picture ID, money for the test, and your sample cannot be diluted or watered down or, of course, have any presence of drugs in it. Do you understand that?
Yes, Your Honor.
Okay. So I'll refer the matter to community corrections in the event that you need help with either the tether or the testing and or a bond review. Okay, good luck.
Thank you, Your Honor.
Thank you, Your Honor.
So, my bond was what now? I'm sorry.
The 10,000, 10%, but you need the tether on before you are released, and you need to be signed up for drug testing. And
okay, Your Honor.
You need to understand this. You know, you have a good attorney, but she can only do work if you work with her. So if you were to get out and then start or taking off, it's going to make it almost impossible for her to give you a great defense in circuit court.
I promise you, Your Honor, I'm going to make every court day, Your Honor. I promise you, I'll put it on my kids. Promise you. And I appreciate everything you guys done for me. I am.
Well, the other thing I would say is that it might be in your best interest if you are struggling with use disorders or addiction to get into counseling if you are able to post bond. Because a lot of people have success with group and individual counseling. So it's not enough to say I love my kids and I'm going to change. You have to have active steps to change to make sure that you don't put your kids in danger of being without a father. Okay? Good luck to you.
Thank you, Your Honor.
Happy holidays, Ms. Cole, Frears Cole, I'm sorry.
Happy holidays to you guys too.
All right, so where are we going now?
So left in jail, I have Mr. Poole, Mr. Robinson, and Mr. Taylor, but Mr. Taylor is the one, they said he's on, I have floor 6, floor 4, floor 2, I don't have. Are you on another one, Mr. Hunt?
I am. I was just going to ask for the court's permission or direction from the court. I have a bench trial that's not going to be a bench trial, but nevertheless at 2:30 with Judge Shepard. I'm currently have Latrice Nixon with Mr. Van Team and Mr. Poole, who I understand is in jail with Mr. Van Team. My understanding was he was going to be asking for a brief adjournment of the PCC on both with a bond motion on Mr. Poole.
Well, I know that Mr. Poole is on floor 4. Do you want to go ahead with that real quick?
Sure, the court, whatever the court wants to.
Yeah, let's bring them in.
Poole.
Oh.
This is a People versus Chad Poole. Counsel, identify yourselves, please.
Good afternoon, Your Honor. John Pohan on behalf of the people.
May it please the court, Vincent Van Team on behalf of Mr. Poole.
And what's going to happen today, Mr. Van Team? Are you setting for exam or what?
Your Honor, I'd ask for a short adjournment for discovery.
So you want another probable cause conference?
Yes, that's correct.
How much time do you want?
Your Honor, I would say 3 weeks would be good.
Okay, so let's see. So like the 12th?
Your Honor, could we do the 19th or is that too far?
Mr. Hunt, I'm fine with that. Right? Any problem with that, Mr. Hunt?
No, not at all.
Regarding bond, Mr. Van Team?
Your Honor, I would request the bond right now, I believe, is 15,000 cash or surety.
Yes.
I would request that the court, my client had a hearing before Judge Toya. He's on probation. The judge gave him a personal bond, according to my client. I'd ask the court to consider a 10,000 10% bond or a 15,000 10%. His fiance indicates that she'd be able to post either one of those bonds. He's been recommended to go into drug treatment, Your Honor. So with COVID going on and the holidays, I'd ask the court at least to consider 15,000 10%, if not 10,000 10%.
And do you know how soon he would be in the treatment?
We didn't discuss that, Your Honor, how soon he would be in treatment. Maybe I could just ask Mr. Poole right now. Mr. Poole, the judge is inquiring how soon you'd be in treatment.
He's muted right now.
Okay, all right. It's through community mental health, Your Honor.
Okay. Oh, he's not muted now. You know, Mr. Poole?
Within 48 hours after today, I believe it is, or Christmas, he said.
Okay. Mr. Hunt, any comments?
Your Honor, I'm not going to stand in the way of the defendant getting treatment. If in fact he's going into treatment, I would not oppose the 10% provision added to the bond, Your Honor.
Okay, thank you.
I would just ask though, Your Honor, if he does in fact go into treatment, that Mr. Van Team contact the court so that we know he made it.
Okay. Yeah, that will be a condition. So 10,000 10%, and you are required to be in treatment upon your release. Do you understand that, Mr. Poole?
And I have him muted. I'm sorry. Hold on one second.
It's okay. You do understand that?
Yes, Your Honor.
All right, good luck in treatment. I hope you get everything out of it you can.
I appreciate.
Yep.
And on the 19th, is that 1 o'clock also?
Yes.
Thank you, Your Honor. I'll contact you, Mr. Poole, or you contact me through your fiance as soon as you get into treatment.
All right,
Thank
where
you.
are we going now? You
I
have
have
one more?
another case. I don't know if you want to call that one.
And you said you've spoke with Miss Nixon. I do not see her in my.
She said she was signing on. I talked to her this morning and again this afternoon. Do you want me to call her and have her sign in if she's not there?
I have two names in here that aren't on my docket, and they're not her, but.
Your Honor, if Mr. Van Teen would consider waiving her appearance since he's going to be asking for an adjournment, I'm certainly wouldn't oppose that.
Okay, yes, I would waive her appearance. I discussed that I would be asking for about a 30-day adjournment for discovery, and maybe we could just set it on the 19th.
Okay, that's fine. Anything else?
No, that's it for me, Your Honor, except to say happy holidays and Merry Christmas to JP and to Mr. Stone, Christie, and yourself.
You too.
Thanks, Vince. You too.
Okay, thanks.
Merry Christmas.
Your Honor, I
Pleasure,
was
Your Honor. I
unable
never
to.
know where I'll see you.
Yeah.
I was unable to get my sizes to you for gifts, Your Honor, so I'll try and get that to you by tomorrow.
I'm glad you said Your Honor because I thought you were talking to me. All right. Thanks.
Happy holidays, everybody.
Take care, everyone. Thanks, Christy. All right, see you, Mr. Stone. See you, JP.
All right. So what
All right, you want to try Raekwon Taylor?
Yes, I'm gonna try to see if I can find him again.
I don't know why I showed up today.
I know they're it's like everybody else.
Takes a lot of people to do your job.
Yeah.
So let's see, I'm gonna bring three in. Oh, now they're done from there, so he's not there. Okay. This might be him, maybe. What is your name?
Raekwon Taylor.
Hold on one moment.
All right, this is People versus Raekwon Taylor. If you'll identify yourself.
Good afternoon, Your Honor. Melissa Simmons on behalf of the people.
Good afternoon, Judge Oyster. Attorney Carl Jordan, P number 57226, appearing by Zoom on behalf of Mr. Raekwon Taylor. Mr. Taylor is appearing by Zoom also, Your Honor.
Okay, thank you. Today's the date and time set for probable cause conference. Do you have all of your discovery?
I'm sorry, Your Honor, it looked like my mute button was on. Did you hear my appearance?
I did hear your appearance. Do you have all of your discovery?
Your Honor, at this point, I do believe that I have been given all of the discovery, but Madam Prosecutor may have something to say about that.
Okay, thank you.
Yeah, so I'm still waiting on a few photographs. I believe they're the autopsy photos and the official autopsy report from the officer in charge. But besides that, everything that we have has been turned over to Brother Counsel.
Okay. So the next step is, are we looking at sending it for an exam or what? Or another probable cause conference?
Actually, Your Honor, we are asking for an in-person exam, but I didn't discuss with Madam Prosecutor about getting another PCC. That might be the best route to take. I will leave it up to her.
I would agree with that, Your Honor, just since I know that Judge-elect Kathy Galen will soon be taking the bench and she may have other obligations and would want to set this possibly herself on a specially assigned day where she would be able to hear the entirety of the exam. I know that we've been having some visiting judges and certainly this would be inconvenient to do with multiple judges.
Sure. So I did set one in person for March, but what I'll do is I'll set a probable cause conference for I mean, do you think early February would be enough time to have a meaningful discussion and yet not too much time where, the case of languishing?
I think early February would be an appropriate time, Your Honor.
So possibly the 2nd or the 9th?
Could I have the, either one of those days works for me. Do you have a preference, Madam Prosecutor? I say that because I actually have 2 trials set, one on the 2nd and one on the 9th. I don't think that they will go, so we could set it, and if they do happen to go, I'll have a stand-in. We're setting it for a PCC, Your Honor, or an exam?
PCC.
Yes, so either one of those dates works for me.
Same for me, Judge.
Okay, thank you. So we'll adjourn the probable cause conference to February 2nd at 1:30, at 1 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
I do find good cause, good cause to continue to adjourn the meeting.
Your Honor, let me place on the record, because I told my client, I told Mr. Taylor that I was going to address his bond, but now that you are a visiting judge, I think it would probably be more appropriate for the judge who is going to be handling this case to be the one that addresses the bond. And so I just wanted my client to know that's the reason why I have not brought it up today.
Yeah, and what I'll also do, and I don't know if they'll meet with him or not, but I'll also refer to community corrections for a bond review. I don't know if this category is too high for them, but we'll put it in the pipeline.
Thank you, Your Honor.
Okay,
Perfect. Thank you, Judge.
Is there one more? We have one more, or how many more?
I have 1,
You.
2, 3.
Okay.
And I have nobody on Sakomi, Jeff?
Yeah.
Do we know? I know we had the officers here.
I've called the complaining witness 4 times and left voicemails. I've never heard back from her. I don't expect her to be in the waiting room. Her name is Kim Hardy.
I don't have Mr. Cholog or the defendant here.
Okay. I think Robinson is in jail. Is that correct? He's in custody?
Yes, he is. And I have Mr. Goodman in the waiting room, and I only have 1 jail room left in the waiting room. So let's hope that it's Mr. Robinson.
No.
Are you Mr. Robinson?
Yes, I am.
Okay, great.
Mr. Goodman.
And I think you're still muted.
Good morning, Your Honor. Sorry, good afternoon, Your Honor.
Versus Brian Robinson. Go ahead, counsel.
Good afternoon, Your Honor. Jeff Stone on behalf of the people.
For the record, Judge Attorney Jackson Goodman appearing on behalf of the defendant, Brian Robinson, in this matter, who is present via Zoom.
Thank you. Today's date and time set for a probable cause conference. Do you have all of your discovery?
Yes, I do, Your Honor.
And what are we going to do? Are we going to set it for an exam?
As far as it's my understanding, I'm standing in in place of the attorney record of Richard John Goodman. It's my understanding that this case is going to be where defendant is going to be waiving his preliminary exam, and we would be requesting that it be bound over to circuit.
Okay, thank you. If you could unmute the defendant. Mr. Robinson, you have the right to an exam. If you waive that right, you will not have a hearing in this court or any district court. The people will not have to put forth any evidence against you. Your case will be sent to circuit court for arraignment, pre-trial, and eventual trial. Do you understand that?
Yes, I do.
Is that how you'd like it to go?
I would like to see if I can get it in this court to see if I can get a 7411.
Well, I think that's something that likely the prosecutor will not be looking at until circuit court.
It's my understanding that Mr. Goodman had discussed that prior, and I think that's kind of the idea that Mr. Goodman had going forward, and that's the reason for the waiving of the preliminary exam.
Thank you. So, Mr. Robinson, do you understand that? Like, that's not off the table, but not doable now.
Okay.
And are you waiving freely, willingly, and voluntarily?
Yes, I am.
Okay, thank you. All right, I find that you are doing so. You are bound or discharged, and your court date will be set for an arraignment pretrial in circuit court. I guess we'll just set it for that one.
Yeah, Judge, we do know the information. It'll be assigned to Judge Biernat. His arraignment pretrial dates are, this matter would be set for January 11th at 1:30 p.m.
Thank you.
And I would just like to address bond briefly, Your Honor.
Sure, go ahead.
Your Honor, regarding bond, Mr. Robinson's 43 years old. He's actually been in Macomb County Jail since November 9th. That's 43 days. We would just request, because his bond is $5,000, 10%. It's not something he can currently make. We would be requesting a personal bond in this matter if possible. If the alternative, if the court would allow the bond to be reduced to possibly $2,500 with 10%, that's what we would be requesting.
Mr. Robinson, who would you be living with?
Also on Normandy, Northeast Point.
And you know you can live there? I mean, you have a place?
Yes, yes, sir.
And do you have a job?
I do. I work for Mr. Brigg, Jason Dunn out of Roseville.
Okay. Would you be able to test randomly 9 times per month? Okay. All right. There's a you're not that far from there, are you?
No, not at all.
Okay. So it'd be random testing 9 times per month, $20,000 personal bond, no drugs or alcohol. Do you understand that? Okay. All right. We're all set then.
Ask him. What was that amount? I'm sorry, Judge. We didn't.
20,000 personal.
20,000 personal. Thank you.
Thank you, Judge.
Thank you.
No. Okay, so it looks like I have a plea up on Robert Bowl, and I have a motion hearing, which, did you get the motion, Jeff?
Yeah, I did. I reviewed it.
On the Thomas Kaiser?
Yes.
Okay, so whatever one you want to do. I'm gonna do the plea real quick.
Yeah, I appreciate it. I know Mr. Rabau would. He was really good at getting back to me.
So Bull.
All right. Bye.
All right. People versus Robert Bowl. Counsel, go ahead. Place your appearances on the record, please.
Good afternoon, Your Honor. Jeff Stone on behalf of the people.
Good afternoon, Your Honor. Scott Rabel on behalf of Mr. Bowl, who is present with us through video conference, I believe.
He's joining.
Okay. Okay, and I believe you're muted, Mr. Bull, so you'll have to unmute yourself, please. Okay.
Got you. Yes, sir.
So I understand that there's a plea to add a count to a use of heroin, a 1-year misdemeanor, and the principal charge would be dismissed. Is that your understanding?
That'd be correct, Your Honor.
Okay. Mr. Bull, is anybody forcing or threatening you to plead guilty today?
No, sir.
Has anybody promised you anything other than what I've stated?
No.
Would you be waiving your right to have a trial in front of a judge or a jury and all the rights you would have had at trial?
Yes, sir.
Do you understand that involves, or that includes remaining silent and not have that silence held against you, testifying, ordering witnesses to be present, cross-examining all witnesses? Essentially, Mr. Rabel could have forced the prosecutor to prove his case against you beyond a reasonable doubt. Do you understand that?
Yes, sir.
Are you aware that you may be sentenced to a maximum penalty of up to 1 year in the Macomb County Jail?
Yes, sir.
Are you on probation, parole, or bond in any other court?
No.
And do you, are you satisfied with your attorney's representation?
Yes, I am.
Okay. To the charge of use of heroin, how do you plead?
Guilty.
And were you in the city of St. Clair Shores on or about November 23rd, 2020?
Your Honor, if you'd like, I can voir dire, and I believe it's East Point.
I'm sorry.
Go ahead,
Mr. Rabel.
On November 23rd of this year, 2020, were you in the city of East Point, County of Macomb?
Yes.
And at that time, did you ingest or use the controlled substance heroin?
Yes.
And you had no medical purpose or legal reason to be able to use that controlled substance, correct?
No, I did not.
Satisfied, Your Honor?
Yes, I am. Are you, Mr. Rabel?
Yes.
Thank you. I don't have any history here. What is your client's history?
Your Honor, to my understanding, back in 2005, he had a possession of marijuana, which was under 7411. And I believe he's had a driving while license suspended before. I'm not sure.
No other drug history?
Not to my knowledge, Your Honor.
Your Honor, reviewing the client's criminal history, it looks like the 2005 marijuana conviction was the only drug-related issue this defendant has had. Everything else is traffic.
Okay, thank you. Mr. Bull, how long have you been using heroin?
About 10 years, sir.
And have you ever been in treatment for it?
I have. I currently am.
Tell me about that. What does it look like?
It's a methadone program. I go there every day. It's actually working pretty good. I've had success with it over the last 4 years. For the most part, I've had success with it.
Okay. And are you in any other therapy?
There's therapy with that, yes, inpatient counseling and whatnot, and group therapy.
Okay. Is there anything you want to say, Mr. Rabel?
Yeah, are we inclined to do immediate sentencing in this matter?
Yeah, we can do it.
Your Honor, in regards to Mr. Bull, he is 39 years of age, a native of Michigan. He is a single father and does have 3 children. He's a high school graduate. He has been gainfully employed, Your Honor, for over 7 years at Coney Island as a cook. He is a veteran, Your Honor. He served 3 years in the Army. He is currently in substance abuse treatment, as he advised the court. It's at Biomed. Unfortunately, he does suffer from an addiction, Your Honor. And historically speaking, and more or less, Your Honor, unfortunately, Mr. Bull also relapsed. He's taken the correct steps and measures to get himself back into treatment and get himself back on track. From speaking with Mr. Bull, he does understand the poor decision he made and the addiction he suffers from, and more or less, he would like to get this matter behind him.
Thank you. Is there anything you want to say, Mr. Bull?
Yeah, just that I made a couple bad decisions and it led to me making a big mistake, and I've taken some actions already, and I'm willing to take whatever else I have to do to put this behind me.
What were those bad decisions?
I don't want to justify anything. It's just I made a couple bad decisions that led to me being around the wrong people, and I made the choice to.
You already said that. I'm wondering what the bad decisions were.
Going around the wrong people, pretty much, and it led to me making the choice to do it myself.
Okay. Do you have other people that aren't users or aren't people that use drugs at all?
Yes, I do. Yes. I have family support.
All right. Okay, so what I'm going to order is the minimum you'll have to do, and I don't know you. You may need to do a lot more than this. You know, you have to figure out for yourself what your life is going to look like. How many kids do you have?
3.
How often do you see them when you're not in jail?
About once a week.
Okay.
Weekly.
What are their ages?
9, 7, and 3.
Okay. Do you want to be significant in their lives or not?
Yes, I would to be more than that. Yeah, absolutely, sir.
Well, I don't think you can be if you're using or thinking about using. I mean, I think it's, just how it is. I mean, you have to decide when enough is enough. And I mean, ultimately you can't do it for your kids, but the kids can be motivation to get you into the right spot. And so either you're going to be that guy who, they talk about and they're in therapy about when they're, your age or younger or older, or you'll be their hero who says, gosh, you know what? Dad faced a really, really tough life and some tough circumstances, but he got through it by humility and honesty. And, I want to be like Dad when I grow up. I mean, I think that's what we all aspire to as parents. But at the same time, let's be real. If you're not a safe person for them, it's not good. And that's damage. You've damaged them already. You understand that? And
I do understand that.
I don't say that to bring shame to you. I say that to make sure you're in reality about the tough times they're going through, whether you're being charged criminally or not. By your absence, by your emotional absence and your physical absence, when you're, thinking about it, when you're obsessing about it, when you're hanging around people that aren't, good people for them to be around, let alone for yourself to be around. And so, those are the decisions you have to, am I going to be a father or not? Am I, can I get through my pain and suffering without using things that could land me in jail? That's the key right there. Because we all suffer, we all have pain. Life isn't supposed to be easy, but I just think if you're doing something that could separate you from your children, it's not a good choice. So you'll have the options. Have you ever looked at the Vivitrol shot?
I've looked at some literature on it. Yeah, I've had the most success with the methadone out of anything I've tried. But I have looked at some literature on it.
And do you have any friends that are sober people that have recovered from either heroin or other narcotics?
Yes, I do. I do know some people who have had success.
Okay.
So I know I know it can be achieved.
It can be. I mean, anything can be achieved, but anything can be, blown up also.
I understand, Your Honor.
In the blink of an eye. But like you said, those bad decisions, I mean, there was probably something going on before you made those decisions to hang around those people that you felt you needed to be close to the fire. And so that's what you have to figure out for yourself. Like, how do I get away from that? So I'm not even in the gray area. I'm not even in the yellow, I'm in the green. I'll go. How do I stay in that health zone? That's where you have to figure out with counseling, therapy, whether it's meditation, exercise, whatever it is, eating better. So you don't get to that part where you're going to dip your toe in and blow it up on you. So I'm going to, I'll put you on probation. I'll give you the opportunity. So I hope it works out. I really do. Your court costs are $775, 12 months reporting probation, $40 a month oversight, no drugs or alcohol, random testing approximately 9 times per month. Continue with the biomed at this time. You're gonna have to attend a minimum of Families Against Narcotics 3 meetings, and counseling is required. So I think the best scenario would be you to be in what's called group and individual counseling. whether Biomed offers that or whether you have to go to Eastwood or somewhere else, that's generally the paradigm that works best because you're around others that hold you accountable, and then you're around with a professional that can guide you through those areas that you've been trying to avoid with, your drug usage. So, I don't know. I don't know what's going to happen to you, but I hope that you make some better decisions to create safety for yourself and your family. But ultimately, you're going to find out, and they'll find out. I don't know. So you contact the court, or do they contact him for the probation?
As long as we have his correct address, let me just see it. And are you at 16600 Chestnut in Roseville?
Yes, ma'am.
What is your phone number?
313-675-5882.
And Mr. Bull, do you have an email address?
I don't, not off the top of my head. That's a current one that I can think of.
Access, okay. Okay. All right. Well, good luck. I hope it works out for you.
Thank you, sir.
Thank you, Your Honor. Thanks, Jeff.
We go now.
Thanks, Scott.
And then now I just have Kaiser and Mr. Bozumowski with a motion hearing.
Okay.
All right. I'm going to text Avis and see where he's at.
Yeah, because I don't see him or his.
Voila. Morning.
Good afternoon, Mr. Bozumowski.
Good morning, Your Honor. How are you, Walt Bozumowski?
I'm doing fine. People versus, I guess we're still waiting for Mr. Kaiser to be connected.
Okay, Your Honor. I did speak with him this morning.
Okay. I see his name. It looks like, is he connecting to audio right now or?
I'm not sure if it's not showing it. Did you call in by phone?
I did. I spoke to him by phone.
Is he calling in by phone and not internet?
That I do not know.
Mr. Kaiser, can you hear us?
Yes, I can.
Okay. So
I'm sorry, I can't get my camera to work.
Oh, that's fine. We can proceed. You had a motion, Mr. Bozumowski?
Yes, Your Honor, it is my motion. It's a motion to amend the terms of the bond. I'd indicate this is a domestic violence case, Your Honor. This involves a situation where my client was involved in an altercation with his son. Quite frankly, he came out the worst of the combatants in this matter. In any event, Your Honor, there's absolutely no fear for him to either return to the house, be with his wife, be with his son. He's living separately with his mother right now. And he's paying $300 per month for the Scram Tether. One of the problems this family has is purely economic, Your Honor. They've lost their house. They went through a foreclosure proceeding. He lost his job because of COVID and couldn't comply with the requirements of the bankruptcy court. So they fully anticipate having to file a complete bankruptcy in the matter, Your Honor. In any event, I'm asking the court to modify it to allow him to have a personal bond and allow him to be removed from the requirement of providing that Scram Tether. Now, Judge, one more thing has come up since I've spoken with Mr. Kaiser. He advises me that his wife has moved out of his house, the house he's prohibited from going back to in East Point. His wife is living with her oldest child from another marriage in Ortonville. And my understanding that she doesn't go back to the house, and she lives with that daughter with Mr. Kaiser's two children by this. In any event, he would contact with them, and if at all possible, he wouldn't mind returning to his former marital residence because no one's there, and at least he could stay there rather than the obvious difficulties that occur when he's living with his parents.
Mr. Bozumowski,
however,
Mr. Bozumowski, Where does Eric live?
Eric, he is the victim in this matter. I believe he lives with his mother in Ortonville at this point. Now, I also believe that the prosecutor has spoken with Mrs. Kaiser regarding this matter. I wasn't, I'm not privy to that conversation, but I understand that that's the case.
Okay. Mr. Stone, have you talked to the officer in charge at all about the motion?
Your Honor, I haven't talked to the officer in charge. One of my victim advocates did speak to the defendant's wife. She is residing with her daughter, I believe in New Haven. I don't think it's Ortonville. She was aware of the motion. She advises that Mr. Kaiser has made no contact with the son or her for that matter, except to discuss financial matters. So there haven't been any violations regarding the no contact. The family has left the residence, at least for now. So Judge, given the financial situation, I really don't have an objection. I would just ask the court that should the defendant's wife or any of the children for that matter need to return to the marital home to get whatever, that Mr. Kaiser not be present during that time.
Sure. So you confirm with the victim rights advocate that Eric is not at the home?
Let me just check the email. That's correct. She is residing with the mother in the daughter's home in New Haven.
Okay.
Lastly, Your Honor, I would indicate that I have talked to my client. He is already becoming involved in the domestic violence 30-week program. He's gone to different steps there. He's also attempting to go to AA meetings and things of that nature. So he recognizes he needs a little work, and he's doing that, Your Honor.
Okay, thank you. That's great. As far as the case itself, are we setting this for a trial or another pre-trial, or what are we doing?
This is set for a pre-trial in February 1.
We're going to keep that date?
Yes.
Okay. All right. So at this time, then, your motion is granted. Mr. Kaiser, you may have the tether removed. You may also return to the home to live. You must vacate, though, if the other family members request time to obtain personal effects, and that will be arranged through your attorney.
Yes, sir. I understand.
Okay. All right. Good luck.
Thank you, sir.
Seeing you, Judge. Merry Christmas, Judge.
You too. Take care.
Mr. Stone, Merry Christmas.
You too, Mr. Presmowski. Christy, I texted Mr. Sholaw. I have not heard back from him, so I don't know if you want to